Hearing aid.
Not only that, but first.
Good afternoon, everyone.
Good afternoon, everyone. Welcome to Legal Hour with Connaughts once again. We apologize that this program we had to obviously take a break for at least 1.5 months, but now we will be coming back live on fortnightly basis again to answer all your legal questions regarding immigration and any recent changes in immigration especially. Today we have chosen a topic which is a very hot topic nowadays because recently changes have come into the immigration rules. A statement of intent has come in, and these rules will be applicable from 6th of July next month. So we decided that we will touch upon few of the important changes we think will affect some of our clients and some of the wider audience as well. As usual, we have our head of immigration, Sharia Khan, with us today to answer all your questions. So do feel free to send your questions on our Facebook page, and we will try and answer as many questions as we can. Sharia, how are you?
Very good, thank you. Hello, everyone. As always said, it's been some time, but I'm glad we are back, and hopefully we'll try to be more regular this time. We were in the interim responding to all your questions by emails, but hopefully we'll continue this session as well, which I've been told is quite helpful to the wider audience. So we're basically discussing the recent changes that have come through. And for the first time, I think Oais would agree as well that we've actually read those and we've been surprised that why is this so positive? Why are most of these changes so optimistic? So for a long time, whenever statement of changes would be introduced, it would be very negative in the sense that, you know, there would be cuts or there would be more difficulties or there would be more reductions. But in this statement of changes, it's quite positive. Actually, a new scheme of immigration has been introduced. And then in many strict rules, some flexibility has been introduced, and one of that flexibility is towards people who have overstayed in the UK. So that's for practitioners referred to as paragraph 39E. So what that has done for quite some time is that the Secretary of State would operate a mechanism that if somebody's overstayed their visa for more than 14 days and they've made an application after that period, of course, then the Home Office or the Secretary of State would automatically refuse your application for overstaying, unless, of course, there are serious or compelling reasons beyond your control. However, if you make an application within 14 days, then you're normally excused, that period is disregarded. I say normally because you still need to give some reasons that as to why you overstayed, and you still need to justify that, but the Secretary is usually lenient if the period of overstaying is within 14 days. What's happened now from the 6th of July is that the Secretary of State has said that there was always this confusion in practitioners that how many times can you actually overstay. So let's say if you make an application, that application is refused, what is the normal trend is that once you finish your administrative review, people would make a fresh application within 14 days. The question would be, what would happen if even that application is refused? Can you make one more application within 14 days? And that, of course, our response to that, hidden deep within the immigration rules, was that yes, you can make such an application. But there was that question as to how many times could you do that. Our previous understanding on that, which the Secretary of State has also accepted at this point, is that you could make such applications twice. So basically what that means is you're refused once, you can make yet one more application within 14 days from the point your administrative review or your refusals come in. However, now from the 6th of July, things are changing. So, of course, this in itself appears to be bad news, which is that you will now only have one opportunity. You will only be given this concession one time. So if you make an application, that application is refused, you will only have one period of 14 days to make a fresh application. If that application is also refused, it ends there, then the Secretary of State is not going to normally accept any future applications. So what, interestingly, it's good and bad, and the reason it's good is because if there are many applications where Secretary of State has refused applications for long residence, because the Secretary of State's position is that you've completed long residence 10 years, but there's always a problem in the last few months, because somebody would have, let's say, accrued 9 years 10 months or 9 years 9 months, and at that point the application is refused and they've made an application within 14 days. So the problem would be that although that application is valid, the question would be that has he completed 10 years lawfully or not. And this is an area that is now probably going to go into judicial review, because the Secretary of State is saying this is a concession, which basically means we won't take this period of overstaying against you. But the question is that if I've only completed 9 years, 9 months, and then I've made an application within 14 days, can the Secretary of State refuse the application saying that as per Section 276 you've not completed 10 years lawful residence? Or will the Secretary of State accept that since you made an application within 14 days and at the date of decision you've completed 10 years, we're going to approve this application? So we are hoping that such applications are normally approved. We are hoping that the Secretary of State asks the caseworkers to look at the date of decision, and any application which is made within 14 days, that whole period of 3 or 4 or 5 months should not be counted as overstaying. There's a problem, it cannot be counted as 3C leave because that's defined by statute, so of course that cannot be extended. But this particular period should be considered lawful and legal and not as a period of overstaying. So it's complex. I'm sure I just threw out a lot of sections and numbers, but in summary what we're saying is that if you're making long residence applications, if there are periods of overstaying and if those periods of overstaying are less than 14 days and you're still facing difficulties, if your application's still been refused, you should speak to lawyers, you should speak to us, and we can help you further on that one.
Sure. Could you also explain to our audience, is there any retrospective effect of these changes that are coming in under 39E? Because previously when previous changes were introduced where this period that would be ignored by the Secretary of State used to be 28 days, then it was reduced to 14 days in 2016 November, I believe. Now further changes are being introduced from 6th of July.
Yes.
Now previously, like you've explained, that any applicant would have had 2 chances of making further application. It's been reduced to 1 chance now within 14 days.
Correct.
Would that have any retrospective effect for anyone who has made an application but these gaps were present before 6th of July?
My understanding is that it is not intended to have retrospective effect. So because the wording is for applications made after the 6th of July. So this could be interesting, because the last statement of changes which were introduced at some time in January, the Secretary of State had introduced another rule which was badly affecting a lot of tier 1 entrepreneurs, because the way their absences of being outside the UK was being calculated was changed. The whole formula was changed, and the Secretary of State decided to say it's retrospective, so it applies, doesn't matter if you've been in the country for 3 years. So you're doing your mathematics in a different way to see whether you're in or outside 180 days.
These are the changes came in on 18th of January this year.
Yes.
Okay.
So they've clarified in this particular statement of changes that those changes are not going to have retrospective effect. So basically they tried to be harsh, but they have, as in this statement of changes, said that they won't be retrospective. So my answer to your question also is that my reading is that this is not going to be retrospective. This 14-day thing that we were discussing is going to apply for applications made from the 6th of July. But the argument where I said if your application has been refused on the grounds of overstaying remains the same, because we're trying to simply say that you were still here lawfully, because the Home Office gave you 14 days, but yet when you make such an application they say, hold on, you did not complete the necessary 10 years. So I'm specifically saying this statement of changes might be good news for people whose 10 years application have been refused on the grounds of overstaying.
Good.
And for that, it doesn't matter whether it's been before the 6th of July or after the 6th of July.
Excellent. Well, that's this good news was one of the few changes been introduced past few years now, a positive change, should I say. We're receiving a lot of questions. One of the question is regarding changes brought in with regards to retain right of residence applications. Initially was the case where applicant had to prove that their spouses, once they have divorced, their ex-spouses were exercising treaty rights at the time divorce is finalized.
Correct. Yes.
Now another very positive change, and that is through the courts actually that have come in, that now the date of initiation of divorce will be taken rather than the divorce finalization date.
Correct. I mean this is excellent, something again which came from the courts, which is the usual practice as opposed to the Home Office for one instance. And what would happen is, I would say in practice as well, when we would be instructed on such cases, then we would tell applicants that why don't you go and ask your ex-wife if she's still working, and you would need that evidence up until the point that you get divorced, which might be 6 months from the point that the relationship is broken down. A lot of clients would just look at us and say, well, how can I get that? We're divorced, we're separated. And of course, divorce is usually one of those cases where you're not usually on those good terms where your spouse would be helping you out in your visa application in the future. So there was a great difficulty that a lot of applicants would face. But now the rule is simple. If somebody's relationship is broken down, all they would need to show is that at the point they initiated the divorce, their wife was working, which could be pretty in the early days, so it would be easy to prove evidentially. But if you ask someone 6 months down the road that can you go back to your spouse and get some evidence, it would be way more difficult. So that's something through the courts for EA applicants who are making application on the retained right. Do you want to tell them what the retained right is, just in case somebody's wondering what we're talking about?
I think this is something we discussed in the past, and we have a few videos available on that topic. So if you want to get more information on this, you can visit our website or go back to those videos and watch them, where we have explained in details what type of in what situations you can continue your right as a spouse or ex-spouse of an EA national. Basically, the bottom line is that you have stayed, your marriage has lasted 3 years, and there are certain subcategories, and if you watch those videos, it will be explained in details in those videos. We are getting a lot more questions now. There is another question with regards to it says, can you give me some information about 12 years private life and also family life? I think there's a confusion where our Foreign Secretary has made a statement some time ago regarding allowing people who have lived in the UK for 10 years without leave or otherwise, some sort of allowing them some sort of amnesty.
Yeah.
And from there we had a lot of inquiries as if this policy has already been introduced. So I think this question probably relates to that. Sure.
Well, there isn't as such today a policy which says that if you've stayed in, or an immigration rule which says that if you've been here 10 years or 12 years illegally, that you will be entitled to some form of leave automatically. What that would, of course, all said and done, all kinds of human rights applications are analyzed by the Home Office on a case-to-case basis. So there isn't a automatic rule, just like the lawful 10-year rule, which there's a section defined to it and there are rules and qualifying factors for it. If you complete 10 years lawfully, you'll be entitled to indefinite leave. There is no such rule that if you've completed 10 years unlawfully or without a visa, that you'll be entitled to anything per se. That said, of course, if you've got children, there's another rule, paragraph 276 ADE, where the Secretary of State will consider how if the children have spent 7 years here, they're under 18, then you would be entitled to leave to remain. And that usually now, after 2012 actually, nobody actually is allowed to jump from being illegal, from being an overstay, straight away to getting indefinite leave, which is what would happen when you would spend 14 years illegally. Now what happens is the only operation rule under the private life is 20 years. So if you complete 20 years in the UK, then you're entitled to not indefinite leave, but leave to remain on the 10-year route, which would mean you would be granted 4 more short leaves, or 2.5 year, and then you would get indefinite leave. So in theory, it's 30 years to qualifying if you're an overstayer, because then you get onto a 10-year route and spend another 10 years.
Sure. There's another related question. A lot of times people make applications. For example, they have a child who's not qualifying yet. Child is 6 years under 7 years policy. They make application. By the time application is refused, child is still not a qualifying child. But
Correct.
when they get to the appeal stage, they go to the tribunal. At that time, child has reached the qualifying age of 7 years in the UK and still under the age of 18. A lot of times we hear that we cannot introduce new evidence in the court. It's only at the time of application the circumstances will be considered, or maximum at the time of decision making. But we have discussed it a few times that in human rights appeals you should be allowed to introduce new evidence at the time of appeal itself.
Correct.
So in those circumstances, what would you advise those who have appeals pending and now the applicants have reached qualifying age?
Well, there's this argument that if the child was not 7 at the date of application, but then consequently by the time they reach the courts has turned to 7, whether the judge is under duty. I understand that the Court of Appeal and the Supreme Court potentially might be looking at this point in due course. As things stand, the immigration rule only applies if the child was 7 at the date of application. But that said, the judge can still look at your case outside the immigration rule. So Article 8 essentially is now codified in Section 276. But if you don't meet that requirement, the judge can still go on and allow your appeal under Article 8 of the human rights, which is always something that's going to exist, which is always something that a judge can use to allow a case. So in summary, what I'm trying to say is it doesn't mean your case is hopeless just because your child was not 7 at the date of application. The judge still has the powers, and your barristers, your lawyers would still have the argument to run that the judge can go past the immigration rule and still allow the appeal under Article 8. The focus has to be that you need to show that the child is established, his core, his life established within the UK, and he really can't relocate back to his country. So we do advise that you should have experts preparing reports which could support that, if it is fair to do so, and that would really assist.
Sure. And just to add to what Sher has already mentioned, in a lot of times it helps that if you write to the Home Office just before the appeals, probably a few weeks before the appeals and appeal date, and explain to them the situation that child has become now qualifying child, and ask them to reconsider their decision. We have done it in some cases, and in some of the cases we have had positive results where Home Office has decided to withdraw their decision, and it has saved us a lot of time and cost, where applicants have been granted visa outside of the court. So I do suggest that speak to your lawyers and ask them to write to the Home Office before the hearing dates, and ask them to reconsider the applications or their positions. And if it's ask them to take a sympathetic approach, and if they're willing to do so, then it will save you a lot of time and cost.
That's correct.
We have another question. I think this is with regards to divorce. It says, I need to divorce my wife. We've separated now for 3 years. How can I divorce? It's not strictly related to immigration topics which we're discussing today, but I will just briefly answer that question. If you have been separated for 3 years, you can go under one of the categories, which is 2 years separation with consent. So if your spouse consents to separation or divorce, then this is one of the grounds you can use to make an application for divorce. Another topic I wanted to discuss today, in fact we've got another question here. It says, I made an application in Jamaica for an EEA family permit. How long should it take to process EEA family permit application?
My understanding is timing is always difficult as lawyers to advise upon, because we deal with applications from a range of countries. Usually the obligation upon the Home Office is to take a decision within 6 months for all such applications. So that would be the maximum period after which you could possibly take some action.
Sure. Another question we have is there any upper age limit for making an application as an overstay? And the age mentioned here is 85 years. So apparently there is an applicant who is in 85 years, and can he or she make an application under human rights?
Well, again, I guess it would help to know how long that gentleman has been in the country. If he just came last year, of course, then it still means that the Article 8 balance would weigh in favor of his country because he spent 84 years there. So we would need to know how long that gentleman's been here. But assuming that he's been for quite a long time, then we could argue that that he's established here for those number of years, and now he's at a certain age where it would be not proportionate, which is the legal term, to send him back to his country of origin. It's very important to look at all the facts of the case before we could properly advise on that one.
Sure. And another topic I wanted to raise is 39E. We've discussed changes that have come in under 39E. Further changes have been brought into entry clearance applications with regards to long residence 10 years route, and they were brought in line with 39E immigration rule, which was in country. So these are very important and significant changes, I believe. So if you want to shed some light on that as well.
Well, yes. What OS means is that if there were applicants who had overstayed, and by overstayed what I mean is somebody makes an application and they overstay by a few days, But that, of course, in itself would be excused based on the 14 days that I was discussing earlier. But if that person gets a decision on their application some 3 or 4 months later, in effect, they would have overstayed for 3 or 4 months because they didn't have a visa and they made an out-of-time application. When such applicants would go back then to their country of origin and make a future entry clearance application, there was that difficulty that they would be refused because they've overstayed for more than 90 days. And the Secretary of State in some cases could then operate what would be called as a mandatory ban for 1 year, and in some cases more, depending on whether you were forced or
Up to 10 years.
Up to 10 years. But now what they've clarified as for this recent statement of changes is that if you make an out-of-time application, then that whole period up until when that application was being considered is not going to be held against you in a future entry clearance application. I guess that would still require you to make arrangements to leave the country as soon as you get that decision if it was an out-of-time application, because otherwise you're just going to make your matters worse for a future entry clearance application.
So that leads to another situation where someone makes that sort of application which is out of time, it is refused, and they have to leave the country, I believe, within 14 days. Once they have left the country and they make entry clearance application within 14 days again, and then they obtain entry clearance, would their long residence continue in those circumstances if they come back within 6 months?
Well, the requirement for such an instance would be that you leave the country having a valid visa, that you've got leave to remain. It could be even 3C. So the difficulty in that argument would be that when you left the country, you did not hold leave. So although you've come back within 6 months, I think the Secretary of State is going to hold the point that you left without leave against you. But because they've introduced this concession, there is an argument that we could argue that they should be more lenient in such cases.
Yes, and also previously there used to be the case where even if you leave the country with leave to remain, you have to make an application straight away within 14 days.
You need to be effectively back in the country within 6 months.
Within 6 months, yes. Another question we have here is, have you got an application? Okay, this is regarding the stateless person. I think we have got a whole series of programs on that as well.
I think the debates over on that one, almost every application that we've submitted has been successful, especially for Indian nationals. We have cases for other nationalities being submitted as well, but the nationality law of each country is different. But all said and done, especially for Indian children, if they've not been registered, that's how the constitution operates. They are considered stateless. The Home Office is, as far as our cases are concerned, and I'm sure other lawyers would agree, not really disputing this anymore. And those children, if you have completed 5 years, they've been granted British nationality. If they've not been completed 5 years, you can still make an application, but then you'll be given a stateless status. You complete that period of 5 years and then you go on and get nationality. So a lot of people I know are waiting to complete 5 years and they don't think they're entitled to anything before that, or the child is not entitled to anything before that. We would advise that you go ahead and make an application for your child to be considered stateless and not really wait 5 years. There's no point. You're still able to claim something today. You should do that.
Sure. Getting a lot of questions with regards to retained right of residence, even though I initially said that we won't be touching on that topic, but it looks like
public demand.
Public demand, yes. Well, I will just touch upon it very briefly. Basic requirements are that your marriage has lasted at least 3 years with your European national sponsor, and you have lived in the UK for 12 months in a relationship. If these basic requirements are fulfilled, then obviously you can proceed with this retained right of evidence. In addition to those requirements, obviously the requirement is that you have separated via divorce, and we have already explained that you need to show that your spouse or ex-spouse was exercising their treaty rights now at the time of initiating the divorce and not at the time when divorce was finalized. There are other subcategories as well through which you can apply retained right of residence. One of them is if you have separated and it's a domestic violence issue. In these cases, your marriage does not have to last 3 years, and we have done a lot of cases particularly on this issue.
But how does that work with European nationals if the relationship is breaking down because of domestic violence?
Well,
has there been some success?
We have, yes, there have been. We have made few applications, and all of them have been successful so far. Basically, the same rules apply. You have to provide evidence of domestic violence, and that could be in form of any prohibited step orders, any evidence from the police statement, a detailed witness statement from the victim itself, and even if in that case marriage has lasted for less than 3 years. Most of the time Secretary of State will exercise discretion in favor of the applicant, and leave will be granted, retained right of residence will be granted.
I see. Okay, so in such cases, then retained right of residence is granted, because if you're married to a British national, then you get indefinite leave straight
That's
away.
correct,
You get
yes.
settlement. So that's interesting that for European nationals they are granting
Retained
right of residence. Yes.
And they also waive requirements of providing evidence that your spouse was exercising treaty rights at the time of relationship being broken down, which is another good concession for those
That's really good,
victims of domestic violence who have suffered violence in their marital life and now want to continue with their stay in the UK even though relationship has broken down. So it is in line with somehow immigration rules as well, even though the leave they get is retained right rather than indefinite leave to remain.
It's still the same thing at the end, yeah.
Yes, because eventually they will get there.
Eventually they'll get
Yeah.
it. I guess the message is that don't stay with your spouses in a marriage that, of course, comprises of domestic violence. And just because you're concerned about your visas, there are immigration solutions to that, and speak to your lawyers about this point.
Sure. The question, I think you have done a few judicial reviews on this matter as well. How does police caution affect nationality applications in good behavior section? I think it's the character.
It's good character, isn't it? Good character has always been a very hot topic with us lawyers, with the Home Office and the courts. There is no definition, unfortunately, of what comprises of good character and what doesn't. But there was a judgment of 2016, I believe, where it was a High Court judgment, which was very helpful in the sense that somebody had a very small, in my opinion, not very serious traffic conviction, and the Secretary of State had refused their application. From memory, don't catch me on that, I think that person was speeding, and there was no accident and nothing more to that. And he was, of course, I'm not condoning that, but he was given the relevant points and he was given the relevant penalties. But then the Secretary of State in due course went on to refuse his nationality on that particular instance. And the High Court judge took a very prudent, very wise view that that is not something that's serious enough to refuse a person British nationality. So in a similar way, I would answer this question by saying that if you've been cautioned only, a caution usually is one of the lowest things that the police officer could perhaps impose upon an individual, where there is some concern later on to verify something, or maybe if they've just suspected but never really found anything. Let's not forget that that's a mandatory requirement, that if they suspect an individual of any activity, they have to caution you first. But it does not mean, as really and truly for immigration purposes, that you have a criminal record, and which should mean that you should not be refused nationality simply on the grounds of caution. If you have been refused, then it's definitely a case that you should take to a lawyer and discuss further.
Sure. Another question we have is from a mother. She's saying, I've lived in the UK for 8 years and have a child who's a British citizen. So how can I apply for a parent status? Now, she hasn't mentioned whether she currently holds a visa in the UK or not, but I think we can address both the scenarios. So she has a child who's a British citizen. Even if she doesn't have leave to remain, it seems like a pretty straightforward application.
Absolutely. Yeah.
If she already has a visa, then I don't think, if it's an extension issue, I don't think it'll be an issue either. We just need to prove that you are a primary carer of a child who's a British citizen, and as long as you can provide all the relevant documentations, you can actually go into the same day service.
Exactly. I mean, it's a very straightforward case. I'd
Yeah.
be surprised if anybody's told you that you don't have a case and you should just stay on without a visa. So if it is the case that the mother did not have a visa before and the son just got nationality, perhaps because the son completed 10 years in the country, then that could be one instance that we could imagine that this would have happened. You should just go ahead and make an application, and the Secretary of State, as always said, would just need to see that you've got custody of the child, that you're the primary carer of the child, and that's really about it.
Excellent. Now the final topic of the day, UNCRA agreement. In the statement of changes, I think there are some very significant changes when it comes to UNCRA agreement as well. So if you can just briefly touch upon that as well.
Well, again, right when we were starting, we just said that there is good news within the statement of changes. That was the initial view. It's been in due course interpreted good and bad for the Ankara agreement holders. So the good news is that there used to be a 10-year route for those under the Ankara agreement as employees working in the country. Now that's been reduced to 5 years. So instead of waiting 10 years, if you're in the UK as an employee under the Ankara agreement, and if you've already completed 5 years, then you're already up for settlement and you can make such an application. However, those individuals who were here under the Ankara agreement as entrepreneurs, as business persons, Turkish business persons, I believe that's what they refer to, that used to be a 4-year qualifying route. Now that's also flat out been turned into 5. So the Secretary of State, in typical fashion, has put everybody in one box, and I think they're going to have some trouble, and they'll have to either clarify or introduce some more changes to say the 4 years stays 4 year, but the 10 years is thankfully now becoming 5 years.
Excellent. There's a question with regards to, I believe it's for extended family members. It says, is it true that EU family members don't have the right of appeal anymore? I think it's referring to previous case of Salah, when right of appeal was taken off from extended family members other than spouses, or other than your partners, and now it's been, when Salah was overturned in Court of Appeal, I believe, a right of appeal was reintroduced only under 2006 regulations, but 2016 regulations still do not have a right of appeal. So if you have made an application recently, there still be the case that Secretary of State will not grant you a right of appeal if you are an extended family member of an EEA national. And that is because your application is being made under 2016 regulations. So there is a bit of a, I would say, problem with when it comes to making current applications. But if you had a previous appeal under the previous regulations and your right was taken away because of Salah, this is something you can actually
Correct.
Yeah, you can deal with. That's it. I think we have covered everything we wanted to cover today.
But just in the end, I did want to say it's again another topic close to heart. Paragraph refusals and news within the last holy month.
Excellent. Just to finally close on one last statement of change that does not affect too many people, but it does affect some. This is change has been brought into returning residents case scenario where someone already had an indefinite leave to remain, left the country and stayed outside for more than 2 years. I think the small change that's been brought in is that now they only have to show that they have a strong ties to the UK, rather than proving that they have spent most of their life in the UK, which was the previous case scenario.
Yes.
So it is a small change, but it's very significant because it's relatively easy to prove that you have strong ties to the UK rather than proving that you have spent most of your life in this country. So
and you intend to make it your permanent home.
Exactly, yes.
So it's relevant for people who have indefinite leave, but then they've been out of the country for a long period of time, or in some cases more than 2 years.
Excellent. Well, with that, I think this is all the time we had for today. If you have any questions, please do feel free to email us via our website, or you can email us directly. If you have any questions, feel free to post them as well on our blogs, and we'll be happy to answer. Thank you very much.
Thank you.
Thank you.
Right.